The question of whether or not Donald Trump is constitutionally disqualified from running for or holding the office of the presidency is being asked louder and more frequently, and as a matter of fact, is now being considered by multiple state election officials and state secretaries of state. But before we unpack all that, if you haven't yet, please hit that like, subscribe, and the alert bell. Maybe check out my Patreon. I'd appreciate the support. All right, folks, so this is a topic that we've discussed in previous videos. There's an increasing number of legal minds and constitutional scholars who argue that Section 3 of the 14th Amendment disqualifies Donald Trump from running for or holding any federal office, including the presidency. And the idea is that the 14th Amendment was one of many that was ratified or that were ratified in the aftermath of the Civil War. And specifically, Section 3 of the 14th Amendment forbids those officers of the United States, those who served in public office, who took an oath to defend and uphold the Constitution, who then broke that oath by participating in or giving aid and comfort to an insurrection or a rebellion. Basically, they're prohibited from holding office again. If you took an oath to the Constitution, if you were in public office and you betrayed that office, you betrayed the Constitution, you don't get to come crawling back and holding public office, public trust, and public power again. Now, obviously, at the time, the founders were most obviously thinking of the Confederacy, right, the rebel states. But there's nothing in the language of Section 3 of the 14th Amendment that indicates that it's time-locked. It doesn't say only members of the Confederate States of America. It just says any officer, again, who took an oath to the Constitution, who broke that oath, any officer. And so we have no reason to believe that that just cut off from 1861 to 1865. So constitutional scholars on the left and the right, yes, the right, including two constitutional scholars in high standing with the Federalist Society, which is a legendarily conservative think tank, they're arguing that Trump is disqualified. That Trump is disqualified under Section 3 of the 14th Amendment as much as a person who is 32 years old is disqualified from running for president, because you have to be 35 according to the Constitution, or somebody who is not a natural-born citizen is disqualified from running for the presidency, right? It's the same thing, that there has to be no trial, no conviction, no nothing. And so, as the argument goes, it would be ultimately up to, at least in the short term, state election officials and state secretaries of state, those who make the decision of what names to put on the ballot, those who review the qualifications of a particular candidate and decide who goes on the ballot, that they would make the decision. And as a result, an increasing number of state secretaries of state are now publicly commenting on this and saying that they need to look into it, they need to consider it. And so I want to play this clip here because this one in particular is, I believe, the Michigan Secretary of State. She's interviewed by somebody on MSNBC, I think Nicole Wallace, if I remember correctly. And yeah, let's hear what she has to say.
An oath to do.
So, Secretary Benson, I know this conversation is in its earliest stages with sort of the legal framework being put out there just this week by Judge Ludig and by Professor Tribe. But what questions would you have if this is indeed what the Constitution would require folks like Mr. Raffensperger and yourself to do?
Well, thanks, Nicole. I think that's the right way to frame it right now. And first and foremost, I want to be clear. I'm going to follow the law. What the law says is what is going to dictate how I hope all of my colleagues proceed in this moment, in particular around thorny issues like this one. Now, in following the law, that means being very careful, making decisions not from a political standpoint, but from a legal standpoint, and asking questions like about due process. Now, typically, a conviction is used to determine the facts and solidify the facts when someone is deemed ineligible, when there are perhaps thorny issues at play. If we're not going to predicate this on a conviction under the law, then what and how do we ensure due process? How do we define insurrection or rebellion? Who makes that determination? And what potential guardrails do we need to have in place so that this is not this precedent that could be created if this legal interpretation is adopted? How can we avoid that being weaponized in the future in this era of false equivalency by officials who want to block candidates from the ballot simply because they disagree with them politically? So this is a thorny, challenging issue. But and I should emphasize that particularly those of the secretaries in battleground states, I'm going to be talking with Al Schmidt in Pennsylvania, with Cisco Aguilar in Nevada, with Brad Raffensperger, because we know in particular in our states the impact that this decision could have, not just among our voters, but in the nation. And so we're taking this seriously, we're looking at it carefully, and we're weighing all of the thorny issues at play.
All right, so, sorry, I thought she was done there at that point. But yes, listen, that's fascinating. You have a state secretary of state in Michigan, okay? That's a battleground state. saying that they're going to consider this. They're going to look into it. And of course, they voiced concerns about whether or not this, if it is an established precedent, whether or not it could be weaponized. And for whatever it's worth, the constitutional scholars who have endorsed this view, like Lawrence Tribe or Judge Ludig or Ballot and Paulson, the authors of the really extensive law review that dives into the scholarship behind the 14th Amendment, Section 3, and why they do think it applies even to Trump, they're all well aware of the fact that this is going to be incredibly contentious, it's going to be incredibly hostile, and it is, of course, rife with potential for abuse, right? But they think that the Constitution compels it, even despite the controversy, and that it needs to be litigated accordingly. So they think that, state secretaries of state need to make the decision, and that citizens, depending on what the decision is by a state secretary of state. So if a state secretary of state decides to remove Donald Trump from the ballot, of course, conservative citizens are going to sue the state and the state secretary of state, and it's going to be litigated in court because they're going to make the case that no, Donald Trump did not give aid and comfort to or participate in an insurrection or rebellion. He should be on the ballot. Likewise, if a state secretary of state says, yeah, I'm going to keep Donald Trump on the ballot, citizens can sue them too. Like, no, Donald Trump is disqualified from holding the office of the presidency because of Section 3 of the 14th Amendment. Either way, it's going to be litigated, and very likely it's going to end up before the Supreme Court. But beyond the state secretary of state of Michigan right there are others as well. So Arizona Secretary of State Adrian Fontes said Tuesday that his office is figuring out how to handle potential complaints over whether Donald Trump should be disqualified from appearing on the 2024 ballot. Okay. And I think there are others as well. We have to have a final certification of eligible candidates by December 14th for Arizona's presidential preference election. Fontes, a Democrat elected last year, told NBC News. And because this will ultimately end up in court, we are taking this very seriously. There's even another one. New Hampshire State Secretary of State David Scanlon is dealing with the same question as he watches a potential challenge to Trump brewing in his state. I want to draw your attention to that one right now because this one's fascinating. So Donald Trump's qualification to be on the ballot in New Hampshire is actually being challenged by a Republican, and a Republican who campaigned with Trump's support. So it is a Trump-supporting Republican who is like, I don't think he's qualified to be president of the United States because of Section 3 of the 14th Amendment. Corky Messner is his name. Meets with New Hampshire Secretary of State over questions about Donald Trump's eligibility to run for office. A Republican Messner, who was endorsed by Trump when he ran for the U.S. Senate, recently met with State Secretary of State. Let's see. I want to find it here. And, of course, I'm not wearing my glasses. Politics can be messy, but before party or any one candidate comes one thing for lawyer and former U.S. Senate candidate Corky Messner, and that's loyalty to the U.S. Constitution. I took an oath to defend the Constitution against all enemies, foreign and domestic, Messner said. It's that devotion that sparked Messner to join a choir of election advocates who say that Trump may be ineligible to run for office because of the 14th Amendment, which states that a public official can't hold office if they were involved in an insurrection. Some will argue that Trump's alleged efforts to overturn the 2020 election prove that. I think we need to make sure that he is, in fact, qualified, Messner said. It's incredibly, this could be as big of a deal in its own way as the various legal indictments that Trump is facing right now. One from New York District Attorney or Manhattan District Attorney Alvin Bragg, one from Fulton County District Attorney Fani Willis, and two from Special Counsel Jack Smith. This isn't really a matter of a criminal law because there's no conviction here. And that's why so many scholars are saying that this has nothing to do with the trial. Trump doesn't have to be convicted of anything because it's not depriving him of a right. It's disqualifying him in much the same way as a 34-year-old is, again, not having a right to run for president of the United States removed from him. You don't have a right to be president of the United States, okay? Which is why the Constitution can put qualifications on potential candidates, and this is one. So this is fascinating stuff, folks. I can't wait to see where it goes, but I think either way, this is going to become an increasingly hotbed major issue as the political cycle unfolds and as we head into the 2024 election. Let me know what you think in the comments.